Good evening. My name is David Curtis. On behalf of the Board of Student Advisors and Dean Minow, I want to welcome you to the final round of the Ames Moot Court competition. The case before the court tonight, Duke versus United States, was written by Tejinder Singh and Elizabeth Perlogar, both members of the Harvard Law School class of 2008. The case presents two questions. First, whether counsel renders ineffective assistance in violation of the Sixth Amendment by failing to file a notice of appeal at a defendant's request when the defendant has waived his right to appeal in a plea agreement. Second, whether a prisoner may challenge his sentence under 28 U.S.C. Section 2255 when an intervening change in law demonstrates that the prisoner was erroneously sentenced as a career offender. Petitioner Jaden Duke is represented by the Franklin E. Kameny Memorial Team. Jennifer Garnett, Ezra Marcus, Katie McCarthy, Jordan Moran, Yvonne Panchenko, and Tom Ryan. Ezra Marcus and Katie McCarthy will be making oral arguments on behalf of the team. The United States is represented by the Elliot L. Richardson Memorial Team. Jay Cohen, Cody Gray, Spencer Hott, Christina Martinez, Sean Mirsky, and Kevin Nalen. Sean Mirsky and Kevin Nalen will be making oral arguments on behalf of the team. The Honorable Antonin Scalia, Associate Justice of the United States Supreme Court, will preside as Chief Justice of this final round argument. Joining him will be the Honorable Adalberto Jordan of the United States Court of Appeals for the 11th Circuit and the Honorable Patricia Millett of the United States Court of Appeals for the District of Columbia Circuit. No photography of any kind is allowed at any point before, during, or after the argument. We ask that you please remain seated while the oralists are speaking, and please turn off all cell phones at this time. Please hold your applause until all oralists have finished speaking, and remember that the petitioner will be making rebuttal arguments after the respondent has spoken. Best of luck to both of the teams. Enjoy the argument.
All rise. The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. The only case on the docket today is number 13-1677, Duke versus United States. Counsel ready? Counsel for petitioners, please begin.
Mr. Chief Justice, and may it please the court. My name is Katie McCarthy, and along with co-counsel, I represent the petitioner, Jaden Duke. I will address the ineffective assistance of counsel question, and Mr. Marcus will be addressing the career offender issue. We ask this court for permission to split our time evenly, reserving 3 minutes for rebuttal. This case is about a choice reserved by law to Jaden Duke, but made instead by his counsel. The choice whether to appeal is given to a defendant because it is ultimately he, not counsel, who must bear the consequences. But here, despite Duke's repeated and express instructions, Milton Fountain refused to file a notice of appeal. That conduct cannot be forgiven simply because there was an appeal waiver in Duke's plea agreement. Fountain still violated prevailing professional norms by disregarding his client's express instructions. And it was Fountain's choice, not Duke's plea agreement, that foreclosed any access to an appellate proceeding. Thus, under Strickland, Fountain deprived Duke of his Sixth Amendment right.
Well, you say he has a choice, but he exercised his choice. He decided to plead.
Your Honor, it's true.
Why wasn't that the end of it?
It's true that Duke did sign a plea agreement that included an appeal waiver. However, as the court recognized in Jones v. Barnes, the decision whether to appeal is a fundamental decision reserved to the defendant. And we have never forever bound a defendant to the first instance in which they make such a choice. For example, in the context of entering a plea, another fundamental
What if
decision.
he changed his mind later? Never mind counsel. He just changed his mind later. He comes to the court and says, I've changed my mind. Yes, the time for appeal is up, but I've changed my mind. Would we have to listen to that?
No, Your Honor. There are deadlines that have been imposed. In this instance, Duke had 14 days from the time of sentencing in which he could decide whether or not to file a notice of appeal.
So he can lose his right to appeal once he's made the choice, right?
He can lose that right as the court rules may dictate, just as a defendant who enters in a guilty plea may later decide to withdraw that plea at any point before the court accepts it. But once the court has accepted it, the defendant must make a showing of a fair and just reason for withdrawing it.
Why isn't it the same thing here? The court accepted the plea, sentence was entered on it. Why is that not the same? Why does that not have the same legal force?
In this instance, no appeal waiver, not Duke's, not any, could ever foreclose all claims on appeal. As circuit courts have uniformly recognized, there are certain claims that always persist despite the presence of a waiver. So even though Duke entered...
Well, yes, I assume that, if he was snookered into making the plea, if there was some corruption that went into the obtaining of the plea, I'm sure he could appeal that nonetheless. But assuming that the plea was properly received and considered by the judge and entered, what other reasons would there be for setting it aside?
Your Honor, the point here is that Duke still had a proceeding available to him. He may have entered into an agreement that foreclosed some scope of what he could appeal on, but the underlying proceeding was still available. So the fact that his attorney disregarded his client's instructions to file the appeal prejudiced Duke in that way.
Of course, it entirely begs the question. You said he had the proceeding available to him. That depends upon whether his waiver was conclusive or not. If he waived the appeal, he didn't have the procedure available to him. And it would have been probably improper on the part of his counsel to disregard the plea agreement and try to appeal. Don't you think counsel should worry about that?
It may be something that counsel should worry about, and counsel can express that worry in the form of consulting with the defendant and informing him of the risks he may be taking by seeking an appeal, having signed a waiver. But as the court made clear in Roe v. Flores-Ortega, counsel performs deficiently when he disregards his client's express instructions to file a notice of appeal.
If Mr. Duke had been sentenced to a statutory minimum, let's say a 15-year minimum under the Armed Career Criminal Act, would your position be the same?
Yes, Your Honor.
What could he appeal in that case?
At this stage, the question before the court is whether or not his attorney should have filed a notice of appeal.
I know, but if an attorney is supposed to act not only in his or her client's interest, but also ethically as well, and there is absolutely nothing that the client could possibly appeal, why does a lawyer act ineffectively by refusing to go forward with an appeal?
A lawyer who finds his client has no meritorious grounds for appeal has professionally reasonable options available to him, but those come after the filing of the notice of appeal. Had Fountain filed that notice here, he would have bought himself and his client 40 more days, 40 days that counsel could have spent looking through the record, attempting to marshal arguments in favor of his client. It's unclear here, and this is exactly why we don't look at the merits when we're talking about filing.
There's certain grounds on which we allow appeals even when an appeal waiver is found, such as misrepresentation by the government, not following up the deal. Why shouldn't we treat the appeal right that is left to someone who's filed one of these waivers as confined to those specific types of errors, and anything else truly is waived?
Your Honor, we've never parsed the Sixth Amendment right to effective assistance of counsel claim by claim. The right to counsel attaches to certain critical proceedings, and this court has acknowledged that an appeal is such a proceeding. So the underlying question is whether...
The appeal that someone can make who's waived the right to appeal is a very different, limited, and cabined appeal, confined to particular legal grounds. And so why shouldn't we, for someone in this situation, say that is the only critical stage that they would have? That's all their appeal could be limited to.
That would require this court to break from precedent, which says When an attorney error has thwarted a defendant from taking an appeal he otherwise would have sought, we don't look to the merits in the first instance. So the court may hold that once Duke is actually
precedent, we don't have precedent that governs this particular situation. We would be saying that when you have this particular situation, that those narrow grounds for appeal define the scope of the right to appeal you may have left. Does your client fall within any of those recognized grounds?
It's unclear, Your Honor. It seems from the incomplete record we have that it's possible Duke didn't have meritorious claims that would have ultimately succeeded on appeal. But what we're concerned with here is whether or not he had.
As you said earlier, he deprived his client of 40 days in which to gin up a reason for appeal, right? You say just get the 40 days and think of whether there's any reason to appeal later. Is that a responsible way for counsel to behave? I depend on counsel to protect me from frivolous litigants. And you're telling counsel, get 40 days so that this litigant can make up something.
It's absolutely true, Your Honor, that counsel in that 40 days could determine that there was nothing he could ethically bring before the court. And that's exactly why we have the Anders procedure, in which counsel can tell the court, I've gone through the record, I've determined that there are no appeal claims that may have merit, and I'm asking to withdraw from the case.
But here the damage is all done at the time the notice of appeal is filed. That's actually an important strategic development. The Anders brief is later. The problem comes when they actually start that appellate process, because that's when they break the deal. Anders doesn't fix that.
First, Your Honor, it's not clear that filing the notice of appeal would necessarily violate the terms of Duke's plea agreement. The plea agreement says he can't appeal on any specific waived grounds, but the notice doesn't actually set forth the grounds on which he intends to appeal. So it's possible after filing the notice, counsel could find claims that fell outside the scope of the waiver that could be appealed in that case.
It's possible, I guess. That's what you're asking us to adopt, a rule that, appeal now and figure out whether you have any reason to appeal later. Is that really what you're suggesting?
Your Honor, the alternative would be looking at the merits beforehand, and that would put the burden on a lay defendant in this 14-day filing window to articulate to their learned counsel exactly why they
put the
fought.
burden on his counsel.
Well,
That's why we appoint counsel to lay defendants, so that they can make these difficult legal decisions.
For example, in this case, Fountain consulted with his client only 24 hours after sentencing, and he didn't have incumbent on him the responsibility that something like the Anders procedure sets forth to go through the record and to really ensure that his client did not have any claims that could prevail.
Is the reverse rule also true? In other words, if a defendant says, I do not want to appeal, tells his lawyer that after being sentenced, and the lawyer thinks, my client's crazy, you've got great grounds to appeal, and files a notice, is that ineffective assistance?
Absolutely, Your Honor. The court as much as said so in Roe v. Flores-Ortega, and the point here
So this is
that
one of those decisions that is completely defendant-driven, and it's not a strategic decision that a lawyer can make.
like the decision whether to plead, whether to testify, this is a fundamental decision for the defendant to make. And this court has been very clear about that since Jones v. Barnes. The ABA standards, which the court also looks to under deficient performance, echo this commitment to the defendant. They say that counsel should consult with the defendant, should tell his client what risks he may be taking in seeking an appeal, but ultimately it's the defendant's choice alone to make. So when Fountain disregarded his client's clear choice, he violated those prevailing professional norms.
But I think in Flores-Ortega, the reason we were able to say in that context that it would be deprivation of a proceeding is, as the court said, there was no strategic decision involved in the decision to appeal. It was simply a ministerial task. There had been no waiver. Here, the key strategic decision at this juncture is whether to appeal or not. So why shouldn't we, at a minimum, have a different rule, a rebuttable presumption about ineffectiveness, and require it to be shown on a case-by-case basis?
The court in Flores-Ortega was aware of the existence of appeal waivers, and they did say it could bear on whether or not counsel has a duty to consult in the absence of clear instructions from his client.
We didn't say it couldn't also bear on whether someone is ineffective or whether the presumption should be rebutted, did we?
The court there, in fact, said that the question of deficient performance is easily answered in this exact context, where an attorney has consulted with his client, and his client has made the ultimate decision that he would like to seek an appeal.
That case didn't. I'm sorry,
Go ahead.
So that case just didn't involve an appeal waiver, though, where that right of autonomy has been exercised, a decision's been made, and a court has entered a judgment in reliance on it. That seems very different.
The facts of Flores-Ortega did not include a waiver, but the court's substantive discussion, which went to its holding about the duty to consult, did discuss the effect a waiver could have. So the court was clearly aware that these appeal waivers did exist.
That'd be all dictum, of course.
Yes,
So
sir.
you really don't have a holding that helps you.
Well,
Right.
the court,
But let me ask another. What about prejudice? I mean, usually when somebody has to show prejudice, not just that something has gone wrong, but that it has hurt him. Does that not have to be shown here? You say the only prejudice is that he wanted to appeal and counsel didn't let him appeal, but that doesn't necessarily prejudice him. I think it virtually certain that if appeal had been taken, he would have been hit with a longer sentence than what he got, because the government would have reneged on its, or he having reneged, the government is no longer bound by the plea agreement, and it would have added in the firearms charge, and that would have increased his sentence. And that's why counsel did not want to take an appeal in violation of the agreement. So what's the harm to him here? How has he been harmed?
Your Honor certainly may be correct, but what is lost here, what prejudices the defendant, is the opportunity to get in the courthouse door, to take the appeal that he wants to take, not to achieve
Not
a
worth
favorable
anything.
outcome.
Give me something substantial. You're just saying he's deprived of the opportunity to argue before the court a useless case. Is that something substantial?
Even if it may have been useless in Duke's case, that's not true for every defendant. If we adopt this blanket rule that allows counsel to override a decision of his
We don't
client,
need a blanket rule. We could have a case-by-case rule in there. And if someone says, hey, I fall within the category of people who are entitled to appeal despite a waiver, maybe they'll be able to show prejudice.
that rule would turn on whether, for example, Duke had articulated to counsel, I want to appeal because I think I was sentenced on the basis of my race, which may have been an entirely frivolous ground for appeal. Then we would say, in breaking from precedent, that Duke was deprived of the effective assistance of counsel because Fountain didn't file the appeal. This isn't a proper onus to put on the lay defendant.
Why do we need a categorical rule? I still don't get why we have to have a categorical rule one way or the other. Why couldn't we look for prejudice on a case-by-case basis like we do with 95% of all other ineffectiveness claims?
The court could do that, but as I said in Rodriguez, when a defendant has been deprived of an appeal that he would have taken, we don't erect any additional barriers for him to get inside the courthouse door. The key question is whether or not, despite counsel's deficient performance, Duke would have taken an appeal. And as the court below found here, he unequivocally requested the appeal in this instance.
You're
So
just saying that not getting in the courthouse door is the prejudice. And I can't accept that. I don't think that constitutes prejudice. If having gotten inside the courthouse door, he would have been rejected and kicked back out, probably with a heavier sentence.
One of the reasons we ask whether the defendant would have taken the proceeding is because we can't, in fact, know what exactly would have happened. In that 40 days, it's possible that counsel would have found a meritorious claim. It's possible that the government would have chosen, as it has in other cases, not to raise the plea waiver as a defense once Duke got inside the
That
door.
could all be shown on a case-by-case basis as prejudice, could it not?
It would be difficult to know ex ante whether or not something, for instance, the government not raising the appeal, or in this case, as there was an intervening change of law with respect to the career offender, we can't know that ahead of time, which is why we can't attach a presumption of reliability to a proceeding that never took place.
Assume that you have a situation where a defendant enters into a plea agreement, agrees to cooperate against co-conspirators, but the government isn't binding itself to file a Rule 35 motion for substantial assistance until all the cooperation is done. And all that cooperation is not going to be completed until well after the sentencing hearing. The client, in this case Mr. Duke, is well on the way to cooperating. He's 90% there. He's got to testify against one more person in the grand jury, and the government's going to file a substantial assistance motion and cut his sentence in half. The lawyer tells him, you're nuts if you want to appeal because your sentence is going from 268 to 134 in about 2 or 3 months. And the most we could do on appeal is maybe cut your sentence down by a couple of years. He says, I want to appeal. The lawyer says, I'm not doing that because it's suicide for you. There's ineffective assistance there too?
I see my time has expired, Your Honor. We would
Respond to the question.
We would say yes. This is, at the end of the day, a fundamental decision for the defendant to make. It's not the place of the state in the form of the court or in the form of counsel to dictate to a defendant what his subjective priorities should be. Thank you.
Thank you, counsel. Mr. Marcus? Proceed.
Mr. Chief Justice, and may it please the court. The career offender guideline is the federal equivalent of a state three strikes law. When a defendant walks into court with his third drug or violent felony, the sentencing system says to him, "We're done with you. Your sentencing range is no longer going to depend on your particular offense conduct or on your actual criminal history category. You are a career offender, and your sentencing range is going to be as harsh as possible."
Unless the judge thinks otherwise, right? I mean, these guidelines are no longer mandatory. He doesn't get sentenced under the guidelines. He gets sentenced to the minimum and between the minimum and maximum that the statute provides, and the judge is supposed to be guided by the guidelines. Isn't that right?
That's true. The guidelines are advisory in light of the court's decision in Booker. But on this question, whether the guidelines have a meaningful constraining effect, even though advisory, we think the court's decision in Pugh is instructive. Because the guidelines, though advisory, they tell the judge there are legal errors that you can make that are reversible error. They give the judge a starting point, a baseline from which the sentence must be anchored. So, and empirically, the Sentencing Commission has engaged in analysis as to whether the advisory guidelines have a meaningfully different effect in terms of their pull on the sentence that's actually imposed.
Can the rule you're asking us to adopt, can it be limited to career offender errors?
We think we have a limiting principle that should at least make the court comfortable that a wide world of ordinary guidelines errors would not be swept in with the ruling for
Why?
Duke. The difference is that when somebody is sentenced as a career offender, they are no longer meaningfully sentenced as a drug offender. It operates more like a substitute crime of conviction than like an ordinary guidelines enhancement.
So what? I mean, so long as it makes a substantial difference, what difference does it make whether he's being, sentenced as a drug offender or something else? Shouldn't the test be how much difference does it make in his sentence?
The difference in principle is one that echoes this court's miscarriage of justice case law. All of those cases, from whether relief has been available as in Davis or not, as in Hill, Timerack, Figueroa, Reed, all of those cases have looked to the character or magnitude of the error.
Right. Which means how much of his sentence is attributable to the error. Is it a big deal or a little deal? You really expect me to say to the next person who comes up here and he says, this mistake cost me 10 years. And I have to say, well, I'm sorry. It just was not a career offender mistake. It was a different kind of mistake. And he's going to say, so what? Which is what I'm asking you. So what? Surely what counts is how much of an impact it has upon the individual defendant.
Our theory doesn't foreclose the possibility that there might be an ordinary guidelines error with a significant enough impact to outweigh the fact that it didn't have this fundamental undermining character on the nature of the proceeding.
Your limiting principle isn't limited to career offenders, you just said.
It's not mechanical in the sense that we can't draw a bright line that would say with exacting certainty every error that would be...
Isn't that exactly the problem? We can't draw much of any line at all. We're going to open the floodgates to having to look at all of these different sentencing errors and decide whether is 10 years the break point or 5 years or 5 years and 1 month. How is this functional?
Why don't you give us a year? A number of years, 5 years. I mean, that's a coherent line. I can understand that. Anything under 5 years doesn't count. Over 5 years, it does. We can live with that.
That line would
doesn't make any sense, but we can live with it.
That line would have an administrability in its favor, Your Honor. And
it would work for you here.
The problem is that line would be a decision rule inconsistent with the doctrine. The question is, how much was the proceeding undermined? How much was the error inconsistent with rudimentary notions of fair procedure?
Right, but the difficult question, the real difficult question is this. Do you look at the nature of the error, or do you look at the result of the error in figuring out whether or not there's been a miscarriage of justice? You could have a massive constitutional error, but somehow, some way, everything gets fixed, and there's only a difference of 6 months. You could have a really small guideline error, but the effect could be monstrous. A 16-point jump in the offense level for illegal reentry, let's say. So which do you look at?
The answer, Your Honor, is both. And the case law has treated them as essentially hydraulic factors. There have been cases under this court's habeas precedent, notably Esco versus Zerbst, where the mere fact of a defendant's presence or non-presence at a hearing was undermining enough of the proceeding to render that error cognizable. And we think the limiting principle that we would articulate is in line with that tradition. Because what happens differently when a career offender error is engaged in is no longer is the court looking to that defendant's actual offense conduct under Chapter 2 of the guidelines, no longer to adjustments up and down under Chapter 3, and no longer to their actual criminal history category under Chapter 4A. The only thing that matters is they're a career offender. Their sentencing range, as Congress has dictated, should be as high as possible. And
Are you sure there was a career offender error here? I mean, as I understand it, the trial court sentenced your client entirely appropriately, as the law then existed. What's the error? He followed what was the law at the time. Now, are we going to go back and reconsider all cases where the law has since changed? What happened here is the law later changed so that this event, which qualified for the career offender purposes, would no longer qualify. But that's new law. So why, he got justice at the time. That's all you can ask, isn't it?
it's true, Your Honor, that the prevailing law in the Ames Circuit at the time did not reveal that this was an erroneous application of the career offender enhancement. But in this case, the parties are in agreement at both the circuit and the district court levels that the decision announced in the Ames Circuit in Sanchez applies to Duke, that it shows that his enhancement was erroneous. Now, the question of whether an intervening change of law can render an error cognizable under the 2255 question is answered squarely by Davis. In that case, it was a similar change in circuit law that was applied to the petitioner in that case. Because the change showed that his sentence and conviction were erroneous, that error was cognizable. And the same logic should apply here. Now, on the question...
understand your principle again about the career offender, you say, eliminates consideration of individual circumstances?
That's correct, Your Honor.
Is that true? I mean, wasn't the district court look at the 3553 factors? And, I mean, she looked at individual considerations here, did she not?
She did, Your Honor.
Was that forbidden?
No, it was certainly
Could she have
permitted.
departed down as far as you want, as far as you want the sentence to have been in this case?
The district judge certainly could have, and we think...
So I don't understand, I guess I'm back to not understanding your limiting principle, because it's not accurate to say that the career offender categorization precludes consideration of individual circumstances.
It certainly doesn't under the 3553A factors. What we mean when we say precluding the examination of the individual circumstances is, take the example of Duke's argument that he played a minor role in the offense. Normally, that would be a plausible argument that he can make at a sentencing hearing, and a judge would have to ask, under Chapter 3 of the guidelines, how large or how small was his role. Because of the career offender enhancement, that question wasn't considered and rejected. It was legally irrelevant. All of Chapter...
Well, it's legally irrelevant within the guidelines, but it doesn't prevent a judge from varying on that same ground, right?
It's certainly true that judges do, under advisory guidelines, need to consider the 3553A factors. There are two reasons why we would say that fact doesn't mitigate the consequences of the career offender error. The first is that even internal to the 3553A factors, the beginning point of the guidelines range is a critical baseline. And the second is that the judge in this case clearly treated
Wait, before you... I don't know what you mean by that.
Factors...
I mean, just say it is a critical baseline. I'm supposed to nod. What does that mean?
Referring to 3553A 4 and 6, Your Honor. 4 requires that the judge begin from a baseline as dictated by the court's decision in Gall, dictated by the career offender enhancement. And 6, that the judge considers sentencing disparities and sentence Duke in line with other career offenders.
He doesn't have to.
That's true, and we think this might well be a different case if it were clear that the judge had not sentenced Duke in light of his status as a career offender, but had said, on policy grounds, I depart downward. I treat you as a drug offender in line with your actual conviction, your actual criminal history category.
So if the judge here had said, I know I could go down lower, I choose not to, I think this is really the right sentence for you, then it wouldn't qualify for review under 2255? Is that your position? It's only because he or she treated it as almost binding?
I think there's no question that the judge did in this case treat it as almost binding. The inquiry that we would suggest is very similar to the one engaged in when the Sentencing Commission engages in retroactive guidelines amendments. And we have to go back and ask, for example, when the crack cocaine guidelines are amended, and those are applicable retroactively to defendants who committed drug offenses, we have to go back and ask, were they sentenced as drug offenders or were they sentenced as career offenders? And we have to ask, did the career offender enhancement serve as the meaningful basis for the defendant's sentence? That's true because they are mutually exclusive sentencing schemes. Somebody who is sentenced as a career offender, their sentence is not based on their status as a drug offender. And that's the inquiry that courts have to do. They ask, was it in a meaningful sense the basis?
This is to identify whether a claim can be raised under 2255, correct?
That's correct.
And so this is the test for determining whether a violation of the laws of the United States has happened, or what can you please connect your test to the text of 2255 and tell me what the problem is?
Yes, Your Honor. The question is, was this a violation of laws in the United States? And because habeas is essentially an equitable remedy, the court has established the miscarriage of justice test to ask which violations of laws in the United States are severe enough to warrant correction.
I thought we were enforcing the text of 2255A statute. Is that not right?
That's correct.
Right. And so we have to decide that it's a violation of the laws of the United States depending on whether the judge thinks that she would have done a different sentence with or without the guidelines range?
We would frame the question slightly differently. We would say that...
You might frame it differently, but am I right in saying that's how I know whether something's a violation of the laws of the United States?
We would say that any sentencing error is a violation of the laws of the United States, but that not every error nevertheless warrants relief, because not every violation...
Wait, so every violation of a sentence, or every sentencing error is now cognizable under 2255?
That is not the position, Your Honor. It's no different from the court's decisions in Hill, Timrek, Figueroa. Those violations of the federal rules of criminal procedure were undoubtedly violations of laws of the United States, but they didn't arise to the level of miscarriage of justice, as the court articulated as the rule.
What causes this to rise to that level?
What causes this error to rise to that level in a way that those sentencing errors didn't is the significant change it had in the entire sentencing proceeding and the severe impact it had on Duke's actual sentence. He would have started with a sentencing range of 151 months. He got a range that began at 262 months, nearly a decade higher. That impact, combined with the way the career offender error works in a sentencing proceeding, is what we suggest makes it cognizable.
So it's the length of the difference in his sentence that makes it significant enough to be taken account of. Is that it?
We think the impact on his particular sentence is a necessary element to relief. But the limiting principle we would suggest is why the court can grant relief to Duke and feel comfortable that a wider world of guidelines errors won't be swept in, is the pervasive impact on the proceeding itself, the fact that it was a fundamental defect that made everything about that proceeding different. Now,
I ask one thing. What exactly would be the right relief were we to agree with you in this case? Is it to grant a new appeal, or is it to actually, do we forget all about that ineffective assistance of counsel stuff and actually order the resentencing? What do you kind of tossed them both up in your brief. I'm trying to figure out what is the right one legally.
The remedy we would seek is a resentencing under 2255, and in the alternative, if we were to not prevail on the career offender issue for the out-of-time appeal. That's sort of the order of remedies that Duke is seeking. Now, before concluding my final couple of minutes, I want to make sure to address the argument that several of the lower courts have found conclusive, the idea that no sentencing error is cognizable so long as the resulting sentence is below the applicable statutory maximum. The reason why we think that's an incorrect rule, as administrable as it may be, is that it's a decision rule inconsistent with the court's doctrine, both the text of 2255 and the way the court has interpreted it.
You don't dispute that if you got this resentencing that you want for relief, that the district court could impose the exact same or a higher sentence?
That's true. We think it's highly unlikely, but it is true that the district court could impose the same sentence on remand. But nevertheless, that doesn't measure the impact of the error. The impact of the error is that he started with a certain range and received a sentence that it is to a near factual
See, I'm confused,
impossibility.
because I thought this all began with the error was to be measured by the severity of the impact on the length of the sentence. That's what we were looking at to understand why this was a distinct type of claim. And yet now you tell me actually it doesn't matter that the sentence could be exactly the same at the end of the day. That seems like having your cake and eating it too at different ends of the issue.
The fact that he could receive the sentence on remand doesn't change the impact of the error in his initial sentencing proceeding. There's no question that if the judge decides on remand, that she would be totally within her rights to afford the same sentence. In that sense, it's no different from the petitioner in Johnson, who would have been resentenced under advisory guidelines, and yet the
But
court...
Johnson would have been sentenced under a constitutional procedure. You don't have that problem here.
I'm sorry, Your Honor, I'm not sure.
Johnson had constitutional claims in his sentencing, correct?
We would respectfully disagree with that characterization of the Johnson case. The court there was explicit that, albeit in dictum, but the rule that it articulated for career offender errors applied to cases falling outside the Gidding exception. In other words, that cases...
Were there constitutional claims in that case? They were finding of a constitutional violation in that case, correct?
The underlying state convictions were vacated because of a Gidding violation.
Right, so we had to go back to have a constitutional procedure in that case. You don't have that claim here. You want to just go back and get the same sentence imposed again.
Well, we think the likelihood of that is incredibly small. It's notable
Does
that...
it matter if it's small or high?
Well, at least in some of the court's decisions, in Tucker and Esco, the court has noted, even with some affirmative suggestion that there would be the same sentence on remand, that was not enough to deny relief. I see my time's expired. We would simply ask relief on the grounds that his proceeding was fundamentally undermined with a dramatic impact on his sentence.
Counsel for Respondent, Mr. Mirsky.
Mr. Chief Justice, and may it please the court. In this case, Petitioner Jaden Duke made two decisions. First, he decided not to appeal, and he formalized that decision in a waiver in his plea agreement. Second, after the court had accepted that agreement and handed Duke the sentence he bargained for, Duke changed his mind and decided that he wanted...
That's not the sentence he bargained for.
Well, respectfully, Your Honor...
It's a sentence he got, and he may not have a relief, but that's not what he asked for, right?
Respectfully, Your Honor, on page 12 of the record, Duke makes sign the fact that he could receive the career offender guidelines.
That's not a bargain. That's an acknowledgement of what you might get hit with. That's not what he bargained for, right?
Well, Your Honor, what he bargained for was certain concessions.
Bargain means that he asked the district judge to give him that sentence, which would be a very different case. That's not what he asked the district judge to do, right?
Well, not quite, Your Honor, because the bargain here was between Duke and the prosecutor. And so the prosecutor bargained to drop certain concessions in exchange, to drop the firearm charge in exchange for certain things from Duke, namely signing the plea agreement and the waiver. And that waiver included the possibility that he would receive the sentence he did. And so I think he did
He bargained for the possibility of getting that sentence, not he just bargained for that sentence.
Well, that's right, Your Honor.
All right, we'll put it that way.
But I think the key point in this case is that Duke made a second decision, and that was the decision to try appealing after all.
To what? To what, I'm sorry?
To try appealing after all.
Let's talk about that for a second. I presume that in the circuit of Ames, as in every other circuit in the country, there is published case law on what makes an appeal waiver enforceable. So, for example, in some circuits, the 11th for one, if the district judge or the magistrate judge who takes the plea doesn't discuss the appeal waiver with the defendant, just glosses over it, never explains what it really means, that appeal waiver is unenforceable. That claim can always be litigated despite an appeal waiver. Is that the same in Ames?
Your Honor, we don't have the particular case law of Ames in front of us, but I'm willing to stipulate to that fact.
Well, if that's the case, why isn't at least that claim always open to a defendant? And if he or she is successful on that claim, then that opens up a whole host of other possible sentencing errors that might have taken place during the sentencing hearing. And if that's the case, Why not give the defendant the choice as to whether or not to appeal?
Well,
Defendants make bad decisions all the time, and we let them. They say, I want to testify. The lawyer says, don't take the stand. And he says, I can convince that jury. I can see it in their eyes. I can do it. And he says, no, we've prepped. I can tell you that you're not going to do it. With bravado, the defendant takes the stand. It's over. The case is over. We let them do that, right? We let them perjure themselves with some consequences to follow, but we let them do that. Why not let them do the same thing here?
Well, that's right, Your Honor. And I think there's two objections in the question you're asking. And so if I may, I'd like to address each in turn. The first relates to the point that if the waiver wasn't knowing and voluntary, then it was invalid, and Duke could certainly appeal that. The government concedes, of course, that there are unwaived grounds on which a defendant can appeal. And that's precisely why an attorney that fails to recognize a non-frivolous ground for appeal would be ruled both deficient and prejudicial under the traditional application of the Strickland test. And this goes back to a point that Justice Millett made in her colloquy with Mr. McCarthy, which is that the government is not asking for a categorical rule, because that would be to ensnare this court in the same trap that Duke's rule promises. Instead, we suggest that there is a case-by-case inquiry into whether there was real prejudice and real deficiency on the part of an attorney. And so, as you said, if the waiver isn't knowing and voluntary, that's precisely the sort of case in which an attorney should appeal.
If a defendant gets everything that he wants at a sentencing hearing, every single thing, but there's no appeal waiver, and he asks the lawyer to appeal, and the lawyer doesn't file it, is there per se ineffective assistance?
Yes, Your Honor, under Flores Ortega.
Although there's no prejudice whatsoever.
Well,
as a matter of fact, there's waiver in that case.
That's right, Your Honor, but I think there's a key distinction to be made about why there is a per se presumption of prejudice in that case and why there shouldn't be in this case. And I think to understand that point, we have to go back to Strickland and to ask exactly when the court creates per se presumptions. And the Strickland court was very clear on this, as was the court in its companion case, Chronic. A per se presumption is appropriate only where prejudice is so likely that case-by-case inquiry is simply not worth the cost. Now, in a case where there is no appeal waiver and there's limitless grounds on which to appeal, it makes sense for this court to install a per se presumption.
I thought we had other precedent that's looked at deprivations of just particular aspects of trial that were deemed to be so structurally critical that we didn't do this case-by-case analysis. If they were deprived of the right to trial by jury, we wouldn't go back and make this analysis. Why isn't the right to appeal the same type of stage of proceeding? They have a right to that stage. We give them the stage. We don't do this case-by-case analysis. I thought that's what Flores Ortega was reasoning.
Well, Your Honor, it's certainly true that this court has installed per se presumptions in a number of areas, particularly when access to a proceeding as a whole is deprived. And again, we don't dispute any of those cases, and we think those presumptions are appropriate, precisely because in those cases, prejudice was so likely that case-by-case inquiry was not worth the cost.
Are those presumptions rebuttable, by the way?
No, Your Honor. In fact, actually, what Duke is asking for, I think, is a per se rule, or at least he's given no indication to suggest why it is, in fact, just a presumption. But the language of Flores Ortega spoke in terms of
So if we made it a rebuttable presumption, at least when there's an appeal waiver, the government would think that's fine?
Well, Your Honor, I'm not sure how that would be any better than Duke's rule, precisely because in order to...
It would be better because you would have the chance to rebut it by saying there's no prejudice.
Well, except at that point, Your Honor, we're already into a frivolous proceeding, which we don't believe that this court or any other court should have to engage in. The real problem with Duke's rule is that it essentially foists a number of frivolous cases on the appellate courts, all in search of the narrow case, the rare case, to use the language from Duke's brief on page 28, the rare case in which there is an attorney who misbehaved and didn't appeal when they should. And so I think probabilities are key here, Your Honor, precisely because that per se presumption of prejudice is appropriate only when there's a significant probability.
But the appeal is frivolous in whose eyes? The government's eyes?
No, Your Honor, from the judicial perspective.
So we've made the ex ante determination that the appeal is frivolous.
No, Your Honor, that's precisely, I think, what Duke should be here to prove.
No, but you said that to adopt the rule that Justice Millett proposed, we'd be bombarded with a lot of frivolous appeals, right?
That's right, Your Honor.
And my question is frivolous from whose perspective? If you're asking us not to make the ex ante call and not to engage in a case-by-case determination, who determines frivolity? The government? The government thinks most sentencing appeals are frivolous. Sorry,
Your Honor. What I'm trying to point out is that under the rule that's proposed by Duke, there would be a number of frivolous appeals brought before the appellate courts as a matter of direct appeal. Precisely because in this case, for example, Fountain would have appealed on Duke's behalf, the case would have gone to an appellate court, and the appellate court would have thrown out as frivolous.
But why? Why do you say that? The government can waive its right to enforce an appeal waiver, can it not?
That is correct.
And there are times when the government says, you know what? We need this issue decided. We need our prosecutors to have guidance, and we're going to let the court decide this issue.
Yes, sir.
And the government expressly waives its right to rely on the appeal waiver.
That's right.
If the government did that in this case, why is Duke's appeal frivolous?
Well, Your Honor, in Strickland, this court made clear that we do not look to the idiosyncrasies of particular decision makers, including unusual propensities towards harshness or leniency, when deciding whether there is prejudice in a particular case.
But we did that in the case where we said that automatic prejudice was presumed.
Not at all, Your Honor, because in that particular case, the outcome didn't turn on the fact that the government would have to choose not to press the waiver. The point was that in that particular case, the odds were sufficiently high that there was prejudice, that there was no reason that a per se presumption was appropriate.
How many defendants succeed on appeal in criminal cases?
Relatively few, Your Honor, as our brief
Then
reflects.
why, if that's the actual reality of the world in which we operate, why would we come up with that rule of presumed prejudice if most appeals were going to be losers to begin with?
Well, Your Honor, there's a distinction between a meritless appeal, in other words, an appeal that eventually loses, even if it brought a non-frivolous claim, and an appeal that is completely frivolous to begin with.
I know, but you're using the word frivolous, not meritless.
That's right, Your Honor, because what I'm pointing out is that in the average world, when we're looking at cases that don't involve appeal waivers, you're right to suggest that a number of cases lose. But that doesn't mean that there aren't a lot of non-frivolous cases brought in the first instance, and that's all that's required under the Strickland standard.
I'm not sure what you're proposing. Are you not proposing a case-by-case evaluation? Or
We are.
You are. You're not saying that it can never happen. You're just saying, look at the particular case. And when we look at this case, your position is there's not sufficient probability?
No, Your Honor. Sorry.
No, I want your answer. I don't want mine.
Well, Your Honor, we are proposing a case-by-case inquiry, and in this particular case, neither Fountain nor Duke's current attorneys have given us a single reason to believe that Duke's petition would be non-frivolous. And indeed, for that reason, we don't think that Fountain was either deficient or prejudicial. When I'm talking about probabilities...
Of course, if you do this case-by-case thing, it has to go up for this case-by-case thing to be determined. So you really haven't saved us any time. You haven't saved the appellate court any time. They're going to have to evaluate case by case whether it's frivolous or not.
Well, that's not quite true, Your Honor, and that's precisely because it's a question of volume. Obviously, when we compare one individual case under each rule, it's true that courts on collateral review will still have to determine whether an attorney was deficient. But the difference is that under Duke's rule, far more collateral petitions would be brought in the first instance.
You say that, but on what basis do we know that? Hasn't the majority of courts of appeals have recognized this right to appeal? And I don't know that there's any evidence that we've been flooded. I think, quite frankly, for most people, they realize that the risk of appeal and losing their deal is so high that there's already going to be a natural check on these appeals. I mean, why should I worry about this flood that you perceive?
Well, Your Honor, I think there's two answers to that question. The first is to recognize, of course, that we're not in any way trying to suggest that, now every single defendant is going to start bringing these claims. Rather, the point is merely that our appellate system is already overburdened, and unless Duke can show an affirmative and compelling reason for his rule, there's no reason to increase that burden further, even if it's marginal. But the second point, I think, is the point of why there would be an additional volume. And I think the point here is that even if the defendants are more likely to bring these types of claims precisely because they know they have a better chance of winning under Duke's standard. Under Duke's rule, all they have to show is that they told their attorney to appeal, and that's it.
But all they get by winning, if that's what you're describing as winning, is to litigate the merits.
That's right, Your Honor.
Which you say they're going to lose.
Well, that's right.
So in the end, they've lost.
That's true, Your Honor, except the distinct...
And you're asking us to evaluate, as Justice Scalia said, the merits to determine whether or not to weed it out before it gets to the merits.
Well, Your Honor, we're not asking for a determination of the merits, and I think this is something that Ms. McCarthy was conflating. It's not a question of showing the merits in order to get into the courthouse door. It's showing that you have a right to get into the courthouse door, which is to say a right of appeal that's retained and that's non-frivolous.
Well, how would someone in Mr. Duke's position show that a prospective appeal, a hoped-for appeal, would be non-frivolous?
Well, Your Honor, on collateral review, Duke's attorneys would presumably go through the record and say, and again, this is a very easy task for them to do precisely because the appeal waiver narrows the possible grounds on which he could appeal. And so the attorneys would have to go through the ground and say, okay, was this particular waiver valid? If so, that checks off about 95% of cases. And then they'd have to go through whatever remaining grounds there are under circuit law. But, Your Honor, I also want to...
And a court would have to pass on that.
That's right, Your Honor.
So why not just do the merits of the appeal and affirm?
Well, again, Your Honor, I think it goes back to a question of volume. If you're a defendant and you know that on collateral review you have a very low chance of winning because you can't show that there are non-frivolous grounds, then you're not going to file that collateral appeal or that collateral case in the first instance. But under Duke's rule, all you have to show...
You've got a very different view of the collateral system that we operate under. People file 2255 motions to vacate every single day on grounds you wouldn't believe. But they do them because they really have nothing to lose, and they're trying to get out of jail, and they figure, this is my last shot under EDPA to get some sort of relief. So if you think that this is going to stop people from filing, my suggestion is that you might be mistaken.
Well, Your Honor, I'm certainly not suggesting that this would stop all habeas appeals. What I'm suggesting, though, is that I do think it would help at the margin. But even to the extent that this court isn't persuaded by the logic that there would be an increased burden on the appellate system, I think it's important to recognize that Duke's rule would also have significant costs for clients themselves. As we mentioned in our briefs, prosecutors rely on these waivers to ensure finality in a particular case. The second you take away
But they don't really, because they know once it's signed that it doesn't mean what it says, that an appeal still could be taken if the attorney really wasn't effective in advising them about the consequences. Or if the government, changed its behavior at sentencing, didn't uphold its end of the bargain, or if they're one of these other sort of exceptions is there. So going in, it doesn't mean there'll be no appeal for sure. So why does it matter then if someone takes an appeal? There's always a risk of an appeal, and that's sort of part of the deal that you take.
Well, that's right, Your Honor, except the risk, of course, becomes much greater when you can appeal not only on those unwaived grounds, but also on any grounds.
But that's not quite how it works. You can only appeal on those other grounds if you're willing to gamble with losing the entire deal.
That's right, Your Honor, and those are the cases I think we're discussing. And again, I'm not trying to make an argument that this in any way is going to completely overturn and break the appellate system. Rather, the point is, I think, more that it does make a difference on the margins, and it will make a difference for prosecutors knowing that, in some sense, waivers have become less valuable to them.
But isn't it, given that we know there's some grounds for appeal, and there's a potential for grounds for appeal in every appeal waiver, isn't it almost easier for defense counsel, who have a very hard job and are very overburdened, for us to have a bright line rule that just says, if they ask for it, file it? And maybe we can follow the Anders process that's been around for a long time. That's still there for you. Instead of defense counsel having to sit there and go through this debate and weighing with the client. If you want the appeal, I'll file it, and I'll either raise something for you or I'll do an Anders brief, and we're done.
Your Honor, it would certainly be easier, but I don't think it would be nearly as helpful to defendants. At the end of the day, I think an attorney, and I'm sure that Duke's counsel would agree, I think an attorney has an obligation to look at the record and to determine if there are any non-frivolous bases for appeal. And indeed, the ABA standards under Rule 3.1 make it clear that it is unethical for an attorney to appeal when there are only frivolous grounds for appealing. Now, Your Honors, I'd like to
Wait, but that rule doesn't interfere with the ability to file a notice of appeal and then put in an Anders brief, does it?
Respectfully, Your Honor, it does. If you look at the text of Rule 3.1, as we cited in our brief, it does, in fact, refer to filing the appeal and not just filing a brief.
But those abstract rules can't always be applied in the main, because there are times when a district judge is faced with a situation where a defendant is really, really upset at his court-appointed lawyer, has filed bar complaints against him or her, and the district judge decides, you know what, I'm not going to take a chance on there being a problem. I'm just going to relieve that CJA lawyer of his or her duties, and I'm going to appoint a new lawyer for appeal. That new lawyer comes in, and that new lawyer has a day and a half to file the notice of appeal. What do you expect that lawyer to do if the defendant says, I want to appeal, and there's an appeal waiver?
Well, in that particular case, as Strickland itself advises, when you're limited in terms of your resources, including time, obviously that changes the options that an attorney can take.
Well, what would that lawyer do?
Your Honors, I see that my time has expired. If I may briefly answer Justice Jordan's question.
Please.
In that case, I think the lawyer would file the notice of appeal, get the extra 40 days, and then look more thoroughly through the record. But that's
Which is sort of what Mr. Duke's lawyer suggested during her time at the podium.
That's absolutely correct, Your Honor, except in this particular case, there wasn't only 1.5 days to file that appeal. Thank you, Your Honors.
Thank you, counsel. Petitioner's rebuttal? Oh, I'm sorry. The other half of respondents. Mr. Nayland, you've prepared for this.
If you'd like, we can rest on the briefs, Your Honor.
Proceed.
Mr. Chief Justice, and may it please the Court, habeas corpus is an extraordinary remedy reserved for exceptional cases. Yet Duke has given no principled reason to think his case is among them, or to distinguish a misapplication of the advisory career offender enhancement from the wide universe of alleged sentencing errors that even he agrees are not grave enough to justify the costs of collateral review. Granting Duke's request would therefore transform habeas into a tool for routine error correction, and would impose costs on the system that would make justice far more difficult to obtain for litigants of all stripes in cases down the line.
What's your solution? What do you think makes it non-routine and worthy of habeas?
Your Honor, our position is that in order to be cognizable, an alleged sentencing error must, at the very least, have had some legal effect on the sentencing judge's discretion. So this would naturally cover cases where a petitioner's alleged sentencing error placed him above the statutory maximum. But it would also bring
But that would not be a guideline error anymore. You'd be violating statutory law if you did that as a district judge.
Well, Your Honor, what I have in mind...
That's clearly cognizable, right?
Well, Your Honor...
If Congress has said that I can only sentence someone to 10 years in prison maximum, and I decide that 12 is what I want to give, and I give 12, that's certainly cognizable, right?
Oh, of course, Your Honor. But the sorts of cases that I have in mind are cases like the Welch case from the Seventh Circuit, where an enhancement is erroneously applied and thereby boosts both the mandatory minimum and the statutory maximum above what they otherwise would have been. And so if the offender were to be resentenced, the judge would have no authority to reimpose the sentence given the first time. Now, in addition to those cases...
I lost you. Tell me again.
So, Your Honor, certain offenders, for their offense of conviction, should face a statutory punishment capped at 10 years. And yet, when an enhancement, like the armed career criminal enhancement, is applied...
When you're talking about an enhancement to the sentence that they can be given by law or to the guidelines?
Well, it operates in both ways, Your Honor. So the career offender enhancement doesn't work like this. But certain other enhancements where the government has conceded should be redressable on habeas do operate in that fashion.
In what fashion?
In the fashion that they have an effect not only on the advisory range within the statutory minimum and maximum, but they actually affect...
They expand the range lawfully imposable.
Correct, Your Honor.
So would a sentencing guideline error like this one be cognizable if the guidelines somehow returned to their mandatory nature?
If Duke had been erroneously sentenced under the mandatory regime, yes, the government is prepared to recognize that he would be entitled to a resentencing proceeding.
Even though, under the mandatory system that existed some years ago, a district judge still had discretion under Section 4A 1.3 of the guidelines to refuse to sentence as a career offender and to depart along the criminal history axis, which gave the judge the same or similar type of discretion that a judge has now under the advisory guidelines.
Well, respectfully, Your Honor, I don't think that's a fair characterization. Judges had some discretion.
They had discretion to depart along the criminal history axis, right?
Correct.
Every court of appeals agreed with that.
That's correct, Your
Under
Honor.
a mandatory scheme, so that if I had Mr. Duke and he was at 262 to 3 whatever, and I thought that's too harsh for Mr. Duke, that overrepresents his criminal history score, I could go down a level or two on the criminal history axis and end up somewhere at 180, 190 or something like that.
That's correct.
But you say that's cognizable.
I think that would be cognizable, but that doesn't really.
Why is that cognizable? And the discretion given by the advisory sentencing regime not cognizable?
Because the nature of the discretion that judges possess nowadays is markedly different from the discretion they possess, the limited discretion they possessed before Booker. And we can see this quite clearly if we look at career offenders. As the government points out in its brief, 70% of career offenders receive sentences that are substantially below their advisory guidelines range. In fact, in those cases, judges deviate from the bottom of the range by a sufficient magnitude to completely nullify the effect of the enhancement in most cases. And on the flip side, as the 11th Circuit recently pointed out in Spencer, there are numerous examples of district courts reimposing an identical sentence after the career offender
I just want to be
enhancement.
clear, your test is a quantum of discretion test?
I'm sorry, Your Honor?
You have a quantum of discretion test, so you had discretion under mandatory guidelines, but now you have more discretion, and so that's what makes a difference under 2255?
There must at the least be some legal effect on the discretion. So if the quantum has to be above zero, if that's, if that answers the question. But
It was above zero whether it was mandatory or non-mandatory.
well, not in the same way, Your Honor. And
That's what I'm trying to figure out what you
Right.
mean by your same way. It seemed like you had some discretion and now you have lots more discretion, and that's the legal distinction.
I suppose, Your Honor, and I'm not sure that the world would necessarily return to the way it was prior to Booker. But in that world, because the discretion was still substantially limited, and it's worth pointing out that even under a statutory regime, statutes still oftentimes specify limited grounds for exception. And yet we think that if a judge were to commit certain statutory violations, that still would be enough to allow relief.
And what if you had the exact same problem here, same situation, except it turned out that the change in the law that happened, like Sanchez happened here, went to an element of the crime rather than a sentencing factor. Maybe he wasn't a felon in possession of a gun, because it turns out we misunderstood what it meant to be a felon.
Mm-hmm.
You would agree, when it goes to an element of the crime, that the claim would then be cognizable under 2255.
If the change in the law has the effect of altering whether certain conduct violates the criminal law, then yes, Your Honor, we think that.
But if you had the exact same effect on the defendant, but it simply came in the form of a sentencing enhancement, robbing a bank with a gun while having previously been convicted of a felony, sentencing enhancement, you'd have the exact same practical consequence. Then it's not cognizable under 2255?
Well, I don't think it's true that the practical consequence would be exactly the same. The first defendant could not be sent to prison for his conduct. The second defendant could receive exactly the same treatment that he received the first time
Well, he
around.
could be sent to prison for his conduct. It's just a more serious crime subject to a longer sentence if you have that extra element in it.
Well, but making sure that people who are in prison are there because they've actually violated the laws they've been accused of violating is a value that's worth protecting, but that is in no way.
That may well be, but I think it's also a value protecting. If people aren't career offenders, they shouldn't be there for an extra 10 years because someone mistakenly treated them as a career offender. The impact on liberty is the same.
Well, that might be, it may or may not be true that the latter category is worth protecting. Obviously, we think it's not. But that person has to have recourse to different arguments.
I'm not sure you really think it's not. Surely your position is more limited than that. You think it's not when it is purely discretionary whether they get less time or not.
That's exactly correct, Your Honor.
If it was mandatory, you'd say it's okay.
Correct.
Let's talk about a case the court decided many, many decades ago. Barron's. Are you familiar with it?
I am, Your Honor.
Okay. That case involved a situation where a judge under the scheme could initially sentence a defendant to the maximum permitted by Congress, order what is now essentially a pre-sentence investigation report, bring everybody back to court, and re-sentence, right? To anything from 0 to the statutory maximum.
That's correct.
And that case involved a violation of a federal rule because the district judge didn't bring the defendant back and didn't let him allocute at the second sentencing hearing, right?
That's correct.
This court allowed 2255 relief, even though the judge had discretion to do exactly what he did incorrectly the first time.
That's correct.
Why doesn't that case sink that part of your argument?
Your Honor, I think Barron's is a very different case from this one. And I think if we reflect on the facts and the law involved in Barron's, it'll become clear why. Barron's, notably, never mentioned the miscarriage of justice test, which governs...
But it was decided a year after the court enunciated that test.
That's exactly right, Your Honor. It never mentioned
So you think it was just ignored?
Well, but Your Honor, I think the reason why is because, as the court made clear, although there was formally a violation of the federal rules, Barron's had been deprived of, in the court's words, an elemental right, an ancient right, and the deprivation raised grave concerns under both the Sixth Amendment and the 14th Amendment. And so Barron's petition was very different in character from Duke's.
But there was no constitutional violation, right? The court went through great pains to say that it was just a rule-based violation. And the judge could have done the same thing he did the first time around. As a matter of fact, he could have given him an even higher sentence if Mr. Barron had decided to sort of speak out of turn the next time around.
Well, Your Honor, I don't think we can really say that there was no constitutional violation. What's
the constitutional violation?
Well, what the court went out of its way to say is that if Rule 32 had been construed not to guarantee that right, and that was one of the questions, there would have been a grave constitutional question. So at the very least...
But the court has never held or suggested, as far as I know, that allocution is a right that is embedded in the Constitution or any of its provisions, right?
But it wasn't just allocution at issue in Barron's. Barron's and his attorney were not allowed to be present at all, which would violate his right to have the effective assistance of counsel for his defense.
Even though the first time around he decided not to speak, even though the judge gave him the option to speak, and he gave the lawyer the chance to argue in favor of mitigation, and the lawyer chose to say nothing.
But, Your Honor, that wasn't the actual sentencing proceeding that would determine his binding sentence. And I think it's for these reasons that this court has never cited Barron's in any of its non-constitutional Section 2255 cases, and why none of the courts of appeals have thought that Barron's might be relevant to a case like Duke's.
It might just be bad lawyering.
I don't think so, Your Honor.
You cannot ignore the actual holding of a case. I mean, you can ignore the language, you can ignore the dictum, the implications, but you can't ignore the holding. And that case provides 2255 relief for a non-constitutional sentencing error when the judge could have imposed the very same sentence on remand. That seems pretty close to what you have here. A non-constitutional error where the judge could impose the same sentence on remand.
At that level of generality, it's true that the cases resemble one another. But again, when we drill down into the actual right that was violated in Barron's and the legal standard that the court was proceeding under, which was not the miscarriage of justice test, I think it's simply not a valid inference to say that because Barron's was entitled to relief, therefore Duke should be entitled to relief.
So it depends on the importance of the right and not the result?
Of course it depends on the importance of the right. That's why non-constitutional errors arise under a different standard than errors that do have something to do with the Constitution.
What was the standard in Barron's if the error there was non-constitutional?
It wasn't the miscarriage of justice standard.
Well, I know you've said that, so what was the standard?
I think the court wasn't totally clear on the standard that it was employing, as it had been the term before in Hill.
I know, isn't there a pretty decent presumption that if a court sets out a standard in year one, decides a case where the standard is applicable in year two, but doesn't mention it, that the court is applying the standard?
But, Your Honor, I think we disagree over whether the standard would be applicable in Barron's. And again, I think the court's later cases provide guidance to suggest that that standard was not applicable in Barron's, because Barron's has never been cited in any case employing that standard. And so, but Your Honors, to return to Duke's own burden in this case, to provide some way to distinguish the career offender enhancement when it's erroneously applied from the wide universe of other possible sentencing errors that we all agree should not afford relief, I think it's quite clear that he's failed by his own terms. And so, if you recall, as the government points out in its brief, for the vast majority of career offenders, the enhancement contributes somewhere between 39 and 63 months to their sentences. Now, the problem for Duke is that that impact is simply not extraordinary. It's far from the uniquely severe impact.
What's extraordinary? If you're trying to quantify it now?
Adopting his standard, Your Honor.
No, I'm asking you, if you're quantifying it, adopting his standard, what's extraordinary? If he got an extra 15 years in prison, would that be extraordinary? Within the guideline system?
Your Honor, I think the problem is that there is no principled cutoff. There is no non-arbitrary dividing line.
Well, but you're trying to argue on his grounds, right?
I'm trying to argue that his grounds cannot supply the limiting principles that
So
he
that
thinks
means-
is necessary.
But your limiting principle is that there's no principle. Nothing is cognizable. If it's a sentencing error and it's non-constitutional, it's not cognizable, period, end of story, regardless of the consequences or the
Well,
prejudice, right?
With the caveat that if the sentencing error does nothing but affect the advisory guidelines range, then it would not be cognizable.
No matter what the effect is.
Well, that's correct, Your Honor, but I think that goes back to the advisory nature
What
of
does
the
that,
guidelines.
but what does that do to the equitable nature of 2255?
I think it appropriately draws on this court's equitable powers to balance the public and private interests at stake. Precisely because if we recognize that the sort of error Duke alleges here is not meaningfully different from a very broad set of possible sentencing errors, and that the decisions affecting the scope of the advisory guidelines, decisions like Sanchez, come out of this court, the courts of appeals, and the state courts all the time. I think we'd realize that the disruptive capacity latent in Duke's petition really is quite potent.
But is the finality interest the same when you're not trying to upset a conviction where you don't have to bring back witnesses and redo a trial, and all you have to do is go back in front of the judge and say, Judge, he's not a career offender anymore. You've got discretion, figure out what the right sentence is. And the judge brings him in from wherever institution he's being held, listens to the parties, imposes sentence, and you're done. Aren't those different finality interests?
They may be different finality interests, but I think we would be wrong to overlook the significant finality interests that are at stake, even though we're not talking about convictions. We're only talking about sentences. And so while Your Honor is absolutely correct that compared one-to-one, a given resentencing may be less costly and less time-consuming than a given retrial. But again, when we recognize the broad implications that allowing resentencing anytime the law
There are
changes—
awfully broad implications with a rule that says no matter how severe the disparity is in the sentence, and we all admit that he should not have been anywhere near the guidelines range that he was sentenced under. There's nearly a decade of prison time that he's serving because of this mistake. That's a lot to just brush off and go, sorry, oops.
Well, Your Honor, I think that question, again, overlooks the fully advisory nature of the guidelines. Now,
No, I think it's actually a realistic appraisal of how courts look at the guidelines. I mean, we recognized in the Pew case that they have nearly sufficient force of law to trigger the ex post facto clause, and now you want us to turn our eyes to that and say, nah, it's entirely discretionary. That's not what the judge said in this case, and that's not the reality. How do you deal with that?
well, Your Honor, I deal with that in two ways. The first is to point out that statements about the guidelines writ large do nothing to distinguish the career offender enhancement. And if anything, the evidence suggests that the career offender enhancement is less prejudicial than other guidelines enhancements.
Now, you're being very abstract. This judge in this case, did it make a difference to this judge in this case? Can you honestly say it didn't?
No, Your Honor, it's not our position that it didn't make a difference. Of course, the guidelines remain influential. But again, that doesn't distinguish the career offender
It's
enhancement.
more than influential. She said if we weren't a career offender, it'd be a whole different story.
Your Honor, I see that my time has expired. If you'd like, I can respond. Your Honor, that may be true, but in these advisory guidelines days, and considering the repercussions that would follow from allowing resentencing anytime the guidelines are arguably misapplied, the sort of error Duke alleges here simply doesn't amount to the level necessary to justify collateral relief. Thank you.
Thank you, Mr. Nayland. Petitioner, you have rebuttal. Mr. Marcus?
May it please the court, we have 2 points to make in rebuttal. First, on the ineffective assistance of counsel issue, we would simply like to contest the notion that Duke's rule calls for a per se presumption or per se rule as to when the Strickland test is met. A per se rule would be the kind of rule for which an evidentiary hearing would be inapposite. The kind of rule that the Flores Ortega court rejected that the Ninth Circuit had taken below, that counsel should have duty to consult in every case, or that there should be a duty to file in every case. Here, we simply apply the traditional Strickland test under a particular set of facts where a defendant has expressly requested that a notice of appeal be filed, that under those circumstances, the duty to file that notice attaches. Those are the facts that make relief warranted for Duke. Second, on the career offender issue, we would agree with the basic premise of the government that The decision in this case turns on an underlying question of when 2255 relief is available. Is it available only in those cases when the output itself, the actual sentence imposed, is above some applicable statutory maximum, some maximum authorized by law, whether that's the original statute or a changed statutory range because of an enhancement? But to only look at the output is to ignore the entire world of errors that occur in the imposition of the sentence. Sentences
Since
imposed.
you're arguing both issues right now for rebuttal, can I ask you a bridging question? And that is, does the waiver or the settlement agreement more generally, should that inform our manifest injustice inquiry? So you not only have a sentence that could lawfully have been imposed, but a sentence that he agreed could lawfully be imposed and agreed he wouldn't appeal if it would be imposed. Why shouldn't that inform our sense of whether manifest injustice occurred here?
It's true that Duke did in his plea agreement acknowledge at least the possibility that the career offender enhancement could be applied. It seems clear he at least didn't understand the implications of that, because he certainly tried to argue that he played a minor role, which would have been irrelevant when the career offender enhancement was implied. But the effect of the error
I'm sorry, I think you're not arguing that it wasn't a fully informed plea that he entered.
That's absolutely correct, Your Honor. We don't argue that. But the effect of the career offender enhancement was clear at his sentencing. The sentencing judge herself, as Your Honor pointed out, she told him, "I'm troubled by it. I'm troubled by the effect this enhancement has had. It's nearly doubled your sentencing range, but that's Congress's judgment. I'm bound to respect Congress's judgment here. Things would be different if you weren't a career offender."
It's very handy that she said that, but is there going to be a statement like that in every case? And we're going to have to inquire into whether the silent judge was seriously affected or not. What do we do when there's no such statement?
There's no question that habeas relief asks difficult case-by-case questions as to how much a particular defendant was affected. And that's part of how we know Duke was affected. The effect was significant. He was violated. His liberty was violated. It was deprived of him. That's why he should get relief. Thank you.
Thank you, counsel. The case is submitted. The court will retire to consider its judgment.
All rise. You may be seated. All rise.
Be seated. Well, we have considered this matter carefully, not the law, but the lawyers. And the judgment of the court is as follows. The best brief we found to be the petitioner's brief. The best team we found to be the respondents. And the best oralist we found to be Mr. Nayland. That's all we had to decide. The bench will now make a few comments about this whole thing, beginning with Judge Jordan.
I drew the short straw, so I'm going first. First, it's an honor to be here, and I'm glad Professor Manning reached out to me and asked me to come. It's been a real delight. You guys were great. The two issues are hard. They really are. And I think they're hard for both sides. And you guys did a good job of figuring out where the gaps were, where the problems were, and trying to at least address them without being afraid of them. I mean, you got some hard questions that there really are almost no answers to on both sides of the case. And I think that's why it was a good moot court problem. The only thing I would say is what I say to participants every time I go to one of these moot court competitions, which is just remember when you go out in real life that it's supposed to be a dialogue. And obviously this is sort of difficult. You just had a dinner where you were fretting about what was coming and you've been anxious the whole day, the whole week, the whole month, the whole semester. But, as you get your sea legs under you when you go out into practice, remember that it's a dialogue. And if you try to treat it at that, you'll be 100% ahead of the game. So you were all great.
Judge Millett?
Thank you. Well, again, it was a great privilege to be here, and the hard part about making final decisions is it doesn't measure how close and difficult the decision was for us. And these were two spectacular sets of briefs. I would love to get briefs like these every day. And these were 4 spectacular oral arguments. And, they didn't show it. I've done oral arguments. It's a terrifying activity to engage in. It's wonderful and exciting, but terrifying at the same time. And I greatly appreciate all the work and effort they put into this. And any client in the future will be happy to have any of you representing them. Will be very, very lucky. And it's lucky for me to be on this side of the bench hearing fantastic oral arguments. You all 4 were very well engaged with us. You put up with very tough questioning. You knew the record, you knew the case law, you knew your positions. You did what you're supposed to do as well as it can be done. And so I congratulate each of you on jobs well done.
The same here. I congratulate each of you. It was a very good argument. Those of you in the audience, it doesn't get any better out there in real practice. It really doesn't. This is, this is as good an argument as you're likely to hear in any court of appeals, and probably in most cases in my court. You both did fine jobs. A lot of the secret is establishing a rapport with the bench. All of you did that rather well. Bad counsel regard a question as interference with their regurgitating their brief, and that's not the way you should take a question. You should take it as an opportunity to satisfy the judge about a problem that particular judge has. The only time you know for sure you're not wasting your breath up there is when you're answering a question. If you're just repeating your brief, you may be talking about something nobody has a problem with. So good advice for counsel is welcome questions and try to establish that, let us reason together kind of rapport with the court. And I think you all did that well. Nobody tried to run away from the questions or tried to ride over the questions and continue the discussion as though the question hadn't been answered. That was very good. Other than that, congratulations to you and to the teams that backed you up. It was fully as good as one would expect at Harvard Law School. Thank you for a good argument. Here you go.
All right.